Hello viewers. So the topic of today's presentation is regulatory provisions for the import of cosmetics. So cosmetics are regulated under the Drug and Cosmetic Act 1940 and the rule in 1945 and the labeling declarations by the Bureau of Indian Standards BIS. BIS sets the standards for cosmetic for the product listed under the Schedule S of the Drug and Cosmetic Rule 1945. So here's the definition of cosmetic. So according to the Drug and Cosmetic Act, it is defined as any means, any article intended to be rubbed, poured, sprinkled or sprayed on the introduced into or otherwise applied to the human body or any other part, therefore for cleansing, beautifying, promoting attractiveness or altering the appearance, and includes any article intended for the use as a component of cosmetic. So the chapter 3 of the Drug and the Cosmetic Act deals with the import and the cosmetic. So now import of certain cosmetic is being prohibited under the section 10 of the Act rules 134A, 135, 135A of Drug and Cosmetic Rule 1945, and they are basically any cosmetic which is not of standard quality, any misbranded or spurious cosmetic, any cosmetic which contain any ingredient which may render it unsafe or harmful for the use under the directions indicated or recommended. Any cosmetic the import for which is prohibited by the rule, or any cosmetic which contain hexachloroquine, any cosmetic in which lead or arsenic compound has been used for coloring purposes, and any cosmetic which contain mercury compound. So the Government of India in February 2007, the Ministry of Health and Family Welfare has bring amendment in the Drug and Cosmetic Rule 1945, according to the which cosmetic is to be imported into the India has to be registered under the Rule 129D by the licensing authority appointed by the central government under the Rule 21. Usually the DCGI, which is also called the Drug Controller Journal of India, is the licensing authority. There should be a single application made for one or more cosmetic which are manufactured by the same manufacturer, and a registration certificate which is provided, which is valid for 3 years if it is not being cancelled. So viewers, now there are 28 cosmetics which are being placed under the Schedule S to the rule which is imposed in the Indian only after the compliance with the Indian standards, and they are basically skin powder or for infants, toothpaste, tooth powders, skin creams, hair oils, shampoo soap base, shampoo synthetic detergent base, hair creams, oxidation hair dyes, cologne, nail polishes, aftershave lotions, pomades and brilliantines, depilatories, shaving creams, cosmetic pencils, lipsticks, toilet soaps, liquid toilet soaps, baby toilet soaps, transparent toilet soaps, shaving soaps, lip slaves, powder hair dyes, bindi, kumkum powder and henna powder. So basically, viewers, there are some registration guidelines which are being required for the import of cosmetic. So as defined under the Rule 21 of Drug and Cosmetic Rule 1945, all the cosmetic product imported for the sale in India need to be registered with the licensing authority. Application form for registration form number 42 will be filled with the required documents are being submitted to the DCGI CIDISCO FDA Bhavan, New Delhi. This application will be accomplished by the fee specified along with the information and the undertaking in the Schedule D3. Single application in the Form 42 for any number or brands manufactured at the one or more locations by a single manufacturer. Single registration certificate in the Form 43 issued to a particular application in respect of import of any number of brands manufactured at one or more locations by a single manufacturer. So, misbranded and spurious cosmetics have been defined in the section 17C and 17D, as under misbranded cosmetics are if it is contain a color which is not prescribed, if it is not labeled in the prescribed manner, if the label or the container bear any statement which is false or misleading in a particular. So spurious cosmetic, a cosmetic shall deemed to be spurious when if it is imported under the name which is belong to the another cosmetic, if the label or the container bear the name of an individual or a company purporting to the manufacturer or the cosmetic which individually or a company's fixtures or doesn't exist, or if it purport to be the product of a manufacturer of whom it is not truly a product. So, Rule 134 of Drug and Cosmetic Act stipulates that no cosmetic shall be imported which contains a coal tar color other than the one prescribed in the Schedule Q. Coal tar color used in the cosmetic shall not contain more than 2 ppm, that is parts per million of arsenic calculated as arsenic trioxide, 20 ppm of lead as calculated as lead, and 100 ppm of heavy metals other than the lead calculated as a total of the respective metals. So, viewers, here are some offenses and the penalties. So, there are some in contravention in brief and the penalties. So, if the import of spurious cosmetic or the cosmetic which containing any ingredient which is harmful or to use, then the penalty will be imprisonment for the term of 3 years, which may extend to the 5 years, with the fine of 5,000 rupees. And the import of cosmetic whose import is being prohibited under the section 10A is being done, then the penalty will be imprisonment for the term of 3 years, which may extend to 5 years, with the fine of 5,000 rupees. And if the above two contravention is being repeated, then the penalty will be imprisonment for the term of 5 years and the fine which may extend to the 10,000 rupees. And the sale and manufacture of any cosmetic which is not of standard or misbranded cosmetic, then the penalty will be imprisonment for the term of 3 years, which may extend to 5 years, with a fine of 5,000 rupees. So, viewers, there are some documents which are being needed for the import of cosmetic. So here is the checklist of documents. The following documents are required to be submitted for grant of registration certificate. So the firstly is covering letter by the applicant. Form number 42 will be filled. Treasury challan, power of attorney, schedule D3, original or a copy of a label, free scale certificate, marketing authorization letter or manufacturing license if any, product specification and testing protocol, a list of countries where market authorization or import permissions or registration was granted, pack insert it any, soft copies of the information about the brand, product and the manufacturer. The applicant will provide the translated English version or any other document which is another foreign language from qualified translator. In the case where there is no provision for the license to manufacture cosmetic in the country of origin, the importer will provide a declaration of an affidavit to that effect. And lastly, the cosmetic products which are imported into India as a bulk for repackaging for 100% export to other countries will not require registration. So basically, viewers, these are the references which I have been covering to make this presentation. So, thank you.